Administration of Criminal Justice Act seems to be helping in the whole process. But there's a part of the Administration of Criminal Justice Act which people are yet to see a forceful intervention. It's the plea bargain, which before people used to complain that it was being abused. Now it is a legitimate part of our legislation. Has this administration exploited the plea bargain option effectively?
Well, the operation and application of plea bargain provisions contained in the Administration of Criminal Justice Act is evolving. As you rightly know, it is a process that that has to be carried out through chains of first negotiations, agreements, and then involving indeed the executive, and the courts, among others, for example. But then, by way of commencement of process, I think there were a lot of offers, numerous offers that have been received from parties that are that have been prosecuted, and arising from those offers that were made, the Federal Ministry of Justice has taken time to profile them, to review them, and make necessary presentations to the presidency for the purpose of consideration. So what I'm saying in essence, that there are indeed certain offers for plea bargain in line with the Administration of Criminal Justice Act, but then each and every case is being looked into on its own merit, and then the cases, the offers were indeed processed to the presidency for consideration and further directives in that respect. Again, the background of the multiple roles that are expected of it. So it is a multi-agency consideration, particularly involving the executive and the judiciary, and it is being processed accordingly in line with the dictates of the Administration of Criminal Justice Act.
Let's now take prosecution. The foundation for a good prosecution is investigation, and it's a long-time problem in Nigeria. People think that investigation sometimes are not strong enough. Is the government or is your ministry thinking about strengthening the power of investigation through the police or the other prosecutory organizations?
Well, you see, the act of prosecution is multidimensional in approach as it relates to presentation of a cogent case before the court.
I'm not only, in fact, talking about corruption alone.
Yes.
In fact, general crimes.
So generally speaking, investigation cannot be looked into as an end in its own right as far as prosecution process is concerned. So for you, at the end of the day, to have a cogent case, the multifaceted factors must be taken into consideration. Prosecution, for effective prosecution or investigation to succeed, there has to be a multidimensional engagement of other agencies. For example, the essence of investigation at the end of the day is to provide cogent investigation report that could constitute a foundation for framing of charge, cogent and comprehensive investigation that will, at the end of the day, make a case succeed at the prosecution level before the court. So that, in essence, calls for a collaboration, one, of the prosecuting agency, and then two, the investigative agency, and indeed the conduct of the case in its own right before the court. So what we have succeeded in doing is to come up with a kind of national prosecution team, which is intended to be a one-stop shop comprising of the prosecutors, comprising of the investigators, and then indeed the prosecuting lawyers before the court, working together in respect of each and every high-profile case in respect of which we feel the investigation, the prosecution needs to be cogent and all-encompassing. So investigation in its own right cannot be an answer to the success of prosecution, but a collaborative approach between the prosecutors, and indeed the investigators working together in terms of assessing the quality of investigation, enhancing the quality, and at the end of the day ensuring that a cogent and compelling and comprehensive case is at the end of the day presented before the court for prosecution.
The third arm you talked about is international engagement, and we have seen that in this ministry you have signed agreements on anti-corruption and a lot of other things, and in fact repatriation of stolen funds. How successful have you been in that area?
Well, honestly, we have been very successful. Very successful in the sense that, one, we have negotiated substantially with a lot of jurisdictions over identified and ascertained assets, arising from the mutual negotiations. Agreements were signed for repatriation, and then those agreements are being consummated in terms of eventual repatriation. For example, if you are talking of the Swiss, we have signed an understanding and agreement. The only outstanding issue that calls for the eventual that awaits the eventual repatriation of the asset is the involvement of the World Bank factored into the judgment on account of which repatriation was to be consummated. And even at that, we have succeeded in working with the World Bank to ensure, towards the eventual repatriation of the fund. If you are talking of the recoveries, the amount in Swiss, I think, is around $321 million in contention. If you are talking of the funds in U.S., for example, the bottlenecks that have been mitigating against the immediate repatriation of funds are being addressed. And to that extent, we are working towards a possibility of a composite settlement arrangement with the U.S. government, because the existence of the judicial processes, judicial proceedings, hampered the immediate repatriation of funds. So what we are trying to do, because of the fact that the U.S. have a pending judgment for feature order against the asset, we are looking at the possibility of working on a composite settlement with U.S. with a view to eliminate all the pending impediments, judicial impediments that are mitigating against the immediate repatriation. In Jersey, for example, the impediment we had is because the U.S. had international forfeiture order and then was equally a party to a process and proceedings that hampered against the repatriation of the fund. So we have engaged counsel, they are in court, and then we are working toward the direction of either settling the matter.
Area heart-to-heart talk with Abubakar Malami, Senior Advocate of Nigeria, the Minister of Justice and Attorney General of the Federation. It is actually our first outing with him on a one-on-one basis. We have always been with him at various assignments, but this time we said he should do an analysis and assessment of the government of the President Muhammadu Buhari as we clock 2 years under this administration. I hope you have learned from some of the revelations he has made, and of course, looking forward, we hope that Nigeria will march on with these programs.
My work, as it was set out, was to support the government's reform agenda in the justice sector and to support the Minister of Justice around developing priorities that will set out government agenda. And so since coming on board, what I have done is that we worked on the development of a justice reform plan, a 4-year justice reform plan, which we then set the agenda on how and what we want to do within the justice sector. Top on that list for us was how we can review laws that over time has prevented Nigerians from having access to effective justice, and how we can improve on our prosecutorial mandate. The mandate of this ministry, as you know, under Section 174, is the Attorney General's mandate to prosecute and to commence or discontinue cases. We wanted to make sure that that was properly situated within the reform agenda of government. We also were very much interested on improving international cooperation around the way we recover assets from outside the country, international cooperation in terms of criminal assistance from other countries. So when we are seeking for such assistance, we wanted to make sure we can get such support. And so we had to, of course, work closely with other development partners to achieve this purpose. Critically for us also was in terms of, I've mentioned asset recovery, as you know, is a very critical component of the minister's work. My work also includes anti-corruption reform. And so we also worked on the National Anti-Corruption Strategy, which the minister has now finalized. He is now preparing it to go to the Federal Executive Council. The intention is that it will set out for the first time in Nigeria the strategy on how anti-corruption would be managed in Nigeria. So, so that's what we've done. But to add to the impact is something analyzing where this has all gone to and how it's making a difference in the lives of ordinary Nigerians. I think for us, what was very important is that the Ministry of Justice should understand its mandate around helping to articulate, first of all, that every Nigerian, regardless of gender, regardless of sex, regardless of disability or status, should be able to access justice, regardless of where you are, in whatever community you are. And what we've done so far is that we looked particularly at the different zones in Nigeria. And we identified that one of the greatest challenges we have is that, particularly in communities that in the Northeast where we have conflict, that most of them don't even have access to the court system. They don't have access to lawyers. They don't have access to anybody to defend them. And so we've been working closely with some development partners to ensure that those in IDP camps can actually have access to justice. And we started working on an access to justice program, bringing together both the judiciary, the Ministry of Justice liaison office in Borno, Adamawa, and Yobe. We also determined that it would be good to have mobile court systems so that these mobile court systems can be taken to where the IDPs are located, because it is difficult for them to travel from one location to the other. And this is an ongoing project where we have seen significant interest, both at the state level as well as federal level. We've also set up within that framework a justice reform team, looking at how we can achieve this purpose. And that justice reform team works closely with the Director of Public Prosecution of the Federation in this ministry. Secondly, within the Administration of Criminal Justice Act, as you know, the chairman of that, there's a monitoring committee that is required to be set up, and the minister is supposed to host the secretariat. The chairman of that committee is the Chief Judge of the Federal FCT High Court, Justice Bello. Now, we've set up a secretariat here, and the essence of that secretariat is to ensure effective implementation of the Administration of Criminal Justice Act and to monitor how the police, the prison system, the judiciary is implementing that law. And within that law, also, we've also developed a practice direction. In fact, Justice Bello recently just issued a practice direction to ensure that judges are effectively implementing the Administration of Criminal Justice Act. And so that is helping in a way to push forward the reforms that the ministry and the government wants to see around criminal justice reform. I've already mentioned the anti-corruption strategy. We are looking carefully at how we engage with anti-corruption agencies. The relationship between them and the Ministry of Justice, as you know, revolves around prosecution and the extent to which we can make sure that those prosecutions are well articulated and cases are well investigated before they go to court. It's an ongoing review process. And within that framework, as you know, the president inaugurated the National Prosecution Coordination Committee last year, around May last year, so effectively 1 year this year. And that committee is sitting and is continuously engaging with the anti-corruption agencies.
You have so much on your hands, and yes. One area I think you already have an assistance, statutory assistance, is in the existence of the Law Reform Commission. Yes. How much work do you do with the Nigerian Law Reform Commission?
At the moment, as you know, there is an ongoing, the Law Reform Commission, the chairman about a month ago submitted their reports to the Minister of Justice. And the reports were aimed at review of specific laws where they have seen that consistently we have not responded to international standards. And so we have taken on board the report. The Department of Legal Drafting within the ministry is taking forward those reports and looking at it and then adopting where necessary. And after the adoption, it will be forwarded to the president to then transmit to National Assembly. So there's a close working relationship with the Law Reform Commission. Let me also add that when the president came on board, and as we looked at some of there were some bills that were passed in the 7th Assembly. Unfortunately, we couldn't enact them, or the president could not assent because of the time frame between which that bill was supposed to be active and the time when the Attorney General was appointed. We are now, or rather we have reviewed those bills, and they are bills that will impact significantly on the way we fight corruption.
We'll see you again as we continue our assessment of Nigeria in the Justice Ministry in the next weeks to come.
The finals of the Men and Women African Cup of Nations. It's always frenetic. On days such as this, there are no tribes, no religion. Here, Nigerian warriors are out to represent, to show the skills that makes us the best. On days like this, the color is one. The color is green. When we get the job done, it is because we have stuck together. When we celebrate, we stand together. Nigerians, united in victory. We are Nigerians. We are one.
Stress is a normal physical response to an event that makes your nervous system feel threatened at the perception of danger, whether real or imagined, giving your body automatic mobilization process known as the fight, flight, or freeze response. This automobilization response, or stress, is designed to protect your body. When it is working well, it helps you stay focused, energetic, and alert. In an emergency, it spurs you into action to defend yourself. Stress, however, becomes worrisome when it is overwhelming. It can damage your health, your mood, your productivity, relationship, and even your quality of life. Stress is chiefly induced by environmental conditions or stimulus and emotional instability. Work-related stress is the second most commonly reported condition in the self-reported work-related illness. According to research results between 2011 and 2012, an estimated 428,000 workers suffered from work stress. Stress affects different people in different ways, but generally, the chemicals that are released by the body as a result of stress can build up over time and cause various mental and physical symptoms. These include irritability, anger, depression, anxiety, food cravings, lack of appetite, headaches, sleep difficulty, and the list is endless. How one handles one's stress depends on the causes and the symptoms, but it is imperative to note that once the pressure or threat has passed, your stress hormone level will usually return to normal.
Issues in the sports sector remain one of the most debated among Nigerians due to the passion, followership, government involvement, impact on Nigeria's external image and our national life in the sports parliament. The NTA offers Nigerians deep views on issues with experts in the sports sector, offering in-depth analysis, hindsight, insight and foresight towards elevating Nigerian sports to the zenith on the floor of the sports parliament.
So many things have been wrong in sports. We've been talking around it.
We need performance expertise, and you can only get some of these where you have world-class facilities.
How can sports deliver return of investment to attract the kind of money required to take it to the next level?